Welcome to the Supreme Court. We're giving oral summaries of two judgments this morning, and our apologies for the delay. There were a few technical problems before we could get started. This is the oral summary of the Supreme Court's decision in the case of Burnett or Grant and International Insurance Company of Hanover Limited. Introduction. This appeal concerns the proper interpretation of a public liability insurance policy. The liability in issue is that of an employer for the acts of his employee, a door steward at a bar in Aberdeen, killed a man after ejecting him from the premises and restraining him in a neck hold. The main issue on the appeal is whether the insurer is entitled to rely on an exclusion under the policy of, quote, liability arising out of deliberate acts, wilful neglect or default, close quote, of an employee. If so, a further issue arises as to whether there is a liability to indemnify limited to £100,000 as the death was the result of a, quote, wrongful arrest. The background facts. On the 9th of August 2013, Craig Grant was killed as a result of an assault on him by Jonas Marcius, a door steward employed by the Prospect Security Limited, Prospect, to work at the Tonic Bar in Aberdeen. The assault occurred during an altercation which happened following Mr. Grant's ejection from the bar, during which Mr. Marcius applied a neck hold to Mr. Grant, who was later pronounced dead at the scene. The cause of death was mechanical asphyxia caused by the application of the neck hold. Mr. Marcius stood trial at the High Court in Aberdeen for the murder of Mr. Grant. The jury did not accept that Mr. Marcius had asphyxiated Mr. Grant or caused his death, only convicting him of assault. The sentencing judge accepted that Mr. Marcius's actions were badly executed, not badly motivated, imposing a non-custodial sentence. Prospect was insured by the appellant in this appeal, the insurer, under a policy covering public liability. Prospect went into liquidation and Mrs. Grant, the respondent in this appeal, brought a claim for damages in her capacity as Mr. Grant's widow against the insurer under the Third Party Rights and Insurers Act of 2010. The insurer sought to have the claim dismissed on the basis that it was not liable to indemnify Prospect under the policy, as Mr. Marcius's actions fell within the exception of deliberate acts. It was further argued that any liability to indemnify arose under Extension 3 of the policy, which provided coverage for public liability for wrongful arrest limited to £100,000. Mrs. Grant's claim succeeded before the Lord Ordinary, and the insurer's appeal was dismissed by the Court of Session. The judgment. The Supreme Court unanimously dismisses the appeal. Lord Hanben gives the sole judgment. Reasons for the judgment. Issue 1. The deliberate acts exception. The critical issue dividing the parties is what is meant by deliberate acts. The insurer's case is that it means acts which are intended to cause injury, or acts which are carried out recklessly as to whether they will cause injury. Mrs. Grant's case is that it means acts which are intended to cause the specific injury which results, in this case death, or at least serious injury, but that on any view it does not include reckless acts. If, as is common ground, it is not the act which gives rise to the injury that has to be deliberate, the most natural interpretation of the clause is that it is the act of causing injury which must be deliberate. The terms of the policy do not provide any support for an interpretation which draws distinctions between different kinds of intended injury, or between serious and less serious injuries. The insured peril is liability arising out of accidental, quote, injury, and this means all kinds of, quote, bodily injury without differentiation. An interpretation that focuses on the specific injury intended also leads to unsatisfactory and arbitrary results, such that it is most unlikely to reflect the parties' intentions. There is no commercial or other logic in excluding precision injuries, and coverage would depend on the happenstance of whether a targeted injury does or does not result. There are, moreover, real difficulties in identifying and establishing the requisite intention for these purposes. For all these reasons, the relevant intention relates to the liability covered under the policy, namely injury. Deliberate acts under the policy exclusion therefore means acts which are intended to cause injury. Clause 14 does not, however, extend to reckless acts. First, the natural meaning of deliberate acts is the conscious performance of an act intending its consequences. This involves a different state of mind to recklessness. Secondly, while the natural meaning of wilful includes deliberate, wilful is capable of having a wider meaning depending on the context. Thirdly, one context in which wilful may well have a wider meaning is where it relates to a breach of duty. Default or neglect in clause 14 is apt to refer to a breach of duty rather than merely omissions, and this is the most plausible explanation of the use of the adjective wilful. Fourthly, the insurer has not been able to produce any case in which deliberate has been held to include recklessness. Fifthly, if exceptionally deliberate was intended to include recklessness, one would expect it to be made clear what that means in this context. Sixthly, an exemption of reckless acts would seriously circumscribe the cover provided, as it would lead to a very wide and commercially unlikely exclusion, given the nature of Prospect's business. Applying these principles to this case, the insurer is unable to establish that Clause 14 exclusion applies on the facts as found. There was no finding by the courts below of intention to injure, or even recklessness. The conviction for assault does not establish any intention beyond an intention to perform the act of assault, namely the neck hold. The sentencing judge concluded that what was done was, quote, badly executed, not badly motivated, close quote, which is inconsistent with such an intention. Even if deliberate acts included recklessness, the same conclusions would follow due to the sentencing judge's conclusion. Issue 2, the wrongful arrest extension. In light of the conclusion reached on Issue 1, that Clause 14 does not apply, the insurer has no defence to the claim made under the main insuring clause, and the appeal must be dismissed. While it is therefore not necessary to determine the second issue, the Court agrees with the reasoning and conclusion of the Court of Session that the losses claimed do not relate to wrongful arrest, and the factual basis of such a claim is not made out. The appeal is accordingly dismissed.